Good morning, everybody. Thank you all for joining us. Looks like we are almost all in from the waiting room, so I'm going to go ahead and get us started with our normal announcements. Just some Zoom housekeeping tips to start with. Please stay muted unless you want to unmute yourself to ask a question, and you can find your mute or unmute buttons and your start and stop video buttons on your Zoom toolbar. For most of you, that's probably at the bottom of your screen, but your mileage may vary depending on what you're using. That is also where you're going to see the chat bubble, which is the best way to ask questions during the Q&A today. And I'm going to pop a message into the chat right now, so that might make it flash for you. But again, like I said, that's the best way to ask questions or ask for us to clarify something that we've said today as we're talking. This is the information that I just put into the chat also tells you how to submit questions in advance of next week's Q&A. And it also provides you with the link to our YouTube channel, where we post all of our videos, usually within a couple of days of each Q&A, with a list of the topics. And so we do get a lot of repeat questions, and we're happy to sort of repeat and cover the same topics now and then, because we just think it's a good information. It's good to refresh our knowledge about certain topics. And also we know that there's some turnover in the folks that attend the Q&A. But if you ever find yourself with a question and you can't make it to the Q&A, or you don't know when we're going to cover that topic next, you can go to the YouTube channel and search within our channel for the subject matter of the question that you have. So again, just a reminder to stay muted for background noise purposes. And the other reminders that we give you guys every week include our sort of disclaimer that we are not here to give legal advice. That's not something that we can do in this forum. So we're here to talk about general information only. So we do often get questions where people will send us, paragraph long excerpts of their governing documents, or will give us a lot of specifics about a scenario that they're dealing with within their community and then ask for advice on those scenarios or those documents. We can't answer those types of questions. Legal advice can only come from your association attorney, who is familiar with your governing documents, with your specific governing statute, and with the specific circumstances that you're dealing with in your community at any given time. So please just keep that in mind. And that also means that if somebody sends you one of our videos and says, well, you can't do this because of something Valerie said, or Lisa said, or Ken said, or whoever, you can ignore that, because this is not legal advice. So I think I've beaten that dead horse and we can move on from that. We do remind everybody weekly that the chat, like I said, is for asking questions, not for, arguing about legal stuff. We don't usually see people do that in our chats, but it's worth the reminder. We've also been reminding everybody for a while now that the Corporate Transparency Act is still being challenged on a number of different fronts nationally. And when our clients ask whether they should start complying with the CTA now, we are still telling them that it's okay to hold off for a couple more months before starting to take steps to come into compliance, because we don't want folks to waste a lot of time and energy complying with the CTA only for it to be, either overturned or for implementation to be delayed. And so we think waiting until, probably October is reasonable before you start taking steps to come into compliance with that. As an aside, I'm actually working on a restatement for a client right now. And one of the things that we are writing into all of our new governing documents that we're drafting for our communities includes a qualification for board member service that requires board members to be willing to comply with the CTA, because we have heard some stories about people who are serving on the board who don't want to comply with the CTA because they don't want to, give their personal identifiable information to the association, like copy of their ID or whatever. So we are setting it up so that board members have to be willing to comply with the CTA if they want to serve on the board. And we'll be talking more about the CTA as the year goes on, whether it becomes something that we are telling people they have to comply with or not. So you can kind of watch this space for further updates. Also, as a reminder, we've been telling you, I think for the last couple of weeks, that the 2024 legislative changes are now finally showing up on the legislative website. So if you search RCW 6490 and voting or something like that, you will now see the 2024, like the most current update to the statutes now shows up when you're actually looking at the statute online. There's always a little bit of a delay between when the bills become effective and when the actual online stuff that you're looking at actually matches up. And so thankfully that is no longer a mismatch. Reminding everybody, we're not doing a Q&A on August 14th. We've been saying that for a few weeks, but we'll keep reminding you until that date comes. So that's just a couple weeks from now. We just like to take one day off each month during the summer. We are also starting to remind folks that CA Day is coming up in October. It's on October 5th. And if you don't know what CA Day is, there is an organization called the Washington State Community Associations Institute. And their website, if you're interested, is WSCAI.org. And Chelsea, if you could put that into the chat, that would be great. You can go to their website. If you go to the events calendar and look at October 5th, you'll see the information for CA Day. It's Community Associations Day. It happens at the Washington State Convention Center every year. And it's essentially a trade show and an educational programming event where all the different types of businesses and vendors that serve community associations come together. We all have exhibit booths, but we also all pitch presentations to, and then the WSCAI staff picks from the pitches the educational topics that they think will be most valuable to people in community associations in Washington State. So if you serve on a board, if you're a manager, you probably already know who WSCAI is, but if you serve on a board, or if you're a homeowner within a community association and you're interested in more education, check out WSCAI and consider attending CA Day in October. They also have a free member webinar tomorrow, Thursday, August 1st. So if you go to the events calendar and look at tomorrow, you'll see there's an all-member webinar that you can register for. It's free. The speaker is a nationally recognized speaker on issues around exclusionary language and governing documents and other sort of belonging related topics. So I'm really looking forward to that webinar and hope some of you might attend as well. I think that's it for all of the announcements. That took a little longer than usual. Lisa, did you have anything you wanted to add, or should I go ahead and jump into the questions?
Go ahead and jump right in.
Okay. And like I said, put your questions in the chat if you have any, and we will try to get to them at the end if we've got time. So here's our first question. I am interested in seeing if there is a summary of the major changes that will be needed to HOA documents due to the shift from either 6438 or other statutes to 6490 in 2028. I am in a couple of HOAs, both very small. One has documents from the 1980s, the other from 2000. Based on the WSCAI conference in May, we know that we will have to comply with WCIAWA in 2028, but are we required to redraft our documents? In one HOA, we have very little assets and low budgets, and it doesn't seem to make sense to spend thousands of dollars to draft something when the law overrides anything in them anyways. We could just follow the law and explain to members why it's different from the CC&Rs. So I'm going to start with the first part of your question and say there isn't one location, one summary that we're aware of, that we've come across, that summarizes all of the changes and compares WCIAWA to all of the other statutes that are going to be disappearing in 2028. But there are a lot of changes, and in particular, I think HOAs are going to be the ones that notice the most significant changes. Because I don't know if you looked at the HOA Act, but it's like 6 pages long, okay? So it says like next to nothing about almost anything. And you're going to be going from that act, which is very, very short and sparse, to a very long, robust act that contains a lot of new requirements and information that you would not have a way of knowing about if you did not familiarize yourself with the law. So the short answer to your other question, which is, can we just follow the new laws without revising our documents? The short answer to that question is yes. There's no requirement that you rewrite your documents to effectuate the changes that are taking place in 2028. That statute is going to apply to you no matter what come January 1st, 2028. I will say that we have recommended restating documents to comply with Kiowa for like so many reasons. But one of the biggest ones is that if you have documents that say one thing and a statute that requires another, that is going to create confusion within your community. You are going to have owners that are confused by that. You will have owners that don't believe you when you tell them that the statute overrides the documents. And you also have to keep in mind that you're not going to be on the board forever, right? There's going to be board turnover. In some communities, you have a new board member every year or two. Some communities, the turnover is a little bit more slow than that. But just because your current board understands what statutory changes trump your documents does not mean that future boards are going to understand that as well. So I do think that amending and restating your documents is a best practice. I think it allows you to avoid the confusion that I was just talking about. I don't think it has to happen overnight. I do realize that a restatement is a larger budget item, especially for very small communities with low budgets. But nobody's saying you have to do it now or even in 2028. This is the kind of thing where you could add, I don't know, $1,000 to your budget and budget for 5 years and then pay for the restatement, 5 years down the road. So I think my recommendation is that for communities that can afford it or that can budget until the point that they can afford it, it's a best practice. Until then, let's say you know that this is something you'd like to do, but this is just not in the 5-year plan. And you're going to be dealing with this new statute starting in 2028, whether you change your documents or not. I think at a minimum, we would recommend that you contact your association attorney to get legal advice on what conflicts there are between your current documents and the new law, so that you know what things you must do. So for example, some new things that are imposed by Kiowa that are not in the HOA Act, you have to be incorporated as some sort of entity at the state level. You have to have audits unless you are under a certain annual budget amount. And then in that case, you have to vote as a community, not as a board, to waive the audit requirement every year. You have to have open meetings. That's not a change for HOA Act communities, but that's a change for old Condo Act communities and new Condo Act communities, actually. And as HOAs, you have never had a resale certificate requirement before. You will now be required to produce resale certificates when properties within your community are being sold. There are also things that will be unenforceable that might exist in your documents right now. So if you have restrictions on solar panels, if you have watering requirements in your landscaping rules, if you have restrictions on assessment increases, like a cap on how much you can increase your assessments from 1 year to the next, if you have a limitation on how many unrelated people can live in the same house at the same time, those are all going to be unenforceable under the new law. And actually, some of those are unenforceable now. And so contacting your attorney to have them tell you, what do I need to know about the new statute? What am I going to be required to do that's new? And what am I going to be prohibited to do that's in my documents? Would at least provide you with a guideline that you can then leave for future board members so that they have that information, but also that you can share with your homeowners so that they are getting that information from what they might view as a more impartial third-party source. So figure out what the differences are so that you and future board members know, even if you're not going to amend your documents in the near future. So Lisa, did you have anything you wanted to add to that?
No, I was just going to say basically the key is to try and avoid confusion for your owners down the road. So even if, as Valerie said, getting just a memo from your attorney that explains what the differences are, that could cut down on a lot of stress later when an owner says, but this is in our governing documents. And you have to find out from your attorney, oh, no, that's no longer enforceable, or that's not no longer right, according to statute. So yeah, getting something from your attorney would be useful.
Yes. So before you jump into the next question, Ken just dropped something into the chat, which I think we definitely want to highlight. There has been a bill introduced federally in Congress regarding the Corporate Transparency Act. It's HR 9045, which would exempt community associations from being subject to the Corporate Transparency Act.
I saw that email this morning. Yeah.
At the national level is asking everybody to contact their congressperson and urge them to support that bill. So that information is in the chat. I just wanted to highlight that for anybody that might not be looking at the chat. And please, 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 even if it's not your normal thing to call your congressperson and ask them to take a particular action, we would love to see people do that. And for most of them, you will be able to just go to their website and send an email. You don't have to call. And I suspect that once it's been a few days since this bill was introduced, CAI might even provide suggested language for one of those types of emails. And so if they do that, we'll highlight that in a future Q&A.
Yeah, and I mentioned that I got an email this morning from being a member of CAI about this bill, so it may already be in progress there.
Thank you, Lisa.
Mm-hmm.
Ken, you're muted.
I got the email and thought it might be valuable for people to have the information this morning because the sooner this gets spread, the more likely it is that it will be successful.
Yeah.
We have a lot of clients who are interested in not participating in this act.
Yes.
So, all right. Well, that's all. The only reason I joined. Thank you.
Thank you.
I can.
Okay.
Okay.
Lisa.
Next question. I understand section 1 of 649540, but section 2 says that reserve funds can be used to pay for a potential component not in the study without notification. I'm assuming without notification to owners. So for example, if we determine we need to replace part of our irrigation system, but have not included that in our reserve study, we can still use reserve funds to cover it without having to repay the fund. Or does the statute say that we can only use the funds without notifying owners of the charges and providing a repayment plan? So I'm assuming what the question, to restate that, is, do we have to tell the owners, do we have to repay it if it's not in a reserve study? Or if it is a reserve component, even if it's not listed, can we just go along with the regular procedure for reserve funds? The short answer to that question is probably. A reserve component is a defined term or phrase in Wakiowa. And so, it looks like I put the wrong quote in there, but we have
I got it.
a physical component. Yeah, it's in the chat there. So if the irrigation system qualifies as a reserve component as defined in the statute, then probably yes, you could use the regular process for using those funds, even if they were not scheduled in your reserve study. But the best practice here would be to talk to your attorney and also to your reserve professional. If that was something that was missed by your reserve professional and should have been included in your study, it should be in a future, and potentially should be in a future update. You'd want to make sure that that was done so you don't have that happen again. And so if this is not, if the irrigation component is something that is not a general operating expense, then you'd want to make sure that was included in future studies upon communication with your attorney and your reserve professional. If you are worried and after consulting with your attorney and your reserve professional, I kind of have the belt and suspenders approach is comply with that second part of the statute. Go ahead and notify all the owners in the community that you're spending this money on replacement or repair of the irrigation system, and adopt a repayment schedule to re-up your reserve funds, because that's what the second half of that statute says is, if this is not a reserve component and you're going to borrow the money from your reserve fund, this is how you basically pay it back and how you let everyone know and be up front with what's going on. So that would be another possibility, is go ahead and do it, but then send the notice to the owners, tell them how you're going to budget to repay that portion of funds that's withdrawn from your reserve fund. Anything I missed there, Valerie? Anything you want to add?
No, I think you got it. Okay. So I'm going to move on to our next question, which is the Nonprofit Corporations Act, RCW 24.03A, imposes specific and detailed requirements for making a request to access association records under Section 215, subsection 2. None of the 4 common interest community association statutes, as amended last year, impose those same requirements. Are the record access request requirements of the Nonprofit Corporation Act imposed in addition to the requirements of the relevant CIC statute, or do the requirements of the CIC statutes supersede or nullify the requirements of the Nonprofit Corporations Act? And can you direct me to the statute or judicial decision that establishes whether the nonprofit requirements are overridden by the common interest statute. The short answer to the question is you only consult the nonprofit corporation statute if your governing statute is silent on a particular matter. So the records request provisions of the common interest statutes, like Wakiowa and the Condo Act, for example, override the records request provisions of the Nonprofit Corporations Act. And the specific citation for this is in Wakiowa, RCW 6490-400 subsection 4, which says in case of any conflict between the nonprofit statutes and this chapter controls. And there is similar language in the Condominium Act, which is 6434-300. And it essentially says the same thing. And actually, I'm going to take a really quick second here to look at the applicability section of the Condominium Act to confirm whether that particular section of the Condo Act also applies to old act condos. At a quick glance, I don't think that it does. So I think that if you're an old act condo or if you're an HOA, you don't have a specific statutory provision that says your statute overrides the nonprofit corporation statute. However, and again, this is not legal advice. So if you're dealing with a particular type of request from an owner and you want to know how to handle it, consult with your association attorney. But I think it would be a reasonable thing for you to look at these other two statutes, one of which is going to be applied to everybody in a few years, and say, my statute is silent on this thing. Our documents don't require a specific procedure. And we think that it is okay to comply with sort of the records request procedures in Wakiowa as instructive, even if it's not binding on our community. So I suspect that in most scenarios, that would be a reasonable approach. But again, that's not advice for any particular situation. So again, generally speaking, if there are conflicts between your governing statute and your nonprofit statute, your governing statute controls. If there are conflicts between your governing documents and the statutes usually control unless they say otherwise. Sometimes they'll say something like, unless stated otherwise in your organizational documents, then you have to do this thing. Well, if it's got language like that, usually what that means is that your documents control and not the statute. But unless the statute specifically says that, the statute will generally trump your documents. So if you're dealing with a records request from a homeowner, you're going to want to look first to see if, because it's always good to see if your documents impose any specific requirements. And then you're going to want to go to what your common interest statute requires. If you are an HOA Act or an old Condo Act community without this language in your common interest statute, I think it's not unreasonable to rely on the language in Wakiowa about this, as opposed to complying with your nonprofit corporation statute. But again, you'd want to consult with your association attorney to make sure that they agree that would be reasonable under your circumstances. I think that covers the question. Lisa, did you want to add anything to that?
No, I think that covers it. Just to say, we talked a lot about the records, changes in the records sections of the Common Interest Act. So if you want more specific information about what kinds of things you have to provide, you can search on our YouTube channel for that. Okay, next question. I am on a small condo board. A unit is for sale and under contract. The sellers have moved and a resale certificate was provided to the buyers. Somehow, the potential buyer got my phone number and called me wanting to ask questions. I haven't yet returned the call. What can or can't I talk about, or should I just not call them back? Could I be at risk or put the board at risk by responding? This is a good question. And honestly, we get these kind of calls too, when we're doing collections and there may be a property in foreclosure or a property for sale and our name is on a lien or something like that. I think there are a couple of options and a couple of considerations you want to take. First thing is you don't have to call them back. You could certainly just ignore the phone call. You're a board member and not the seller. The resale certificate should speak for itself and should provide the information required to a purchaser from the seller and from the association. But you might think, you can't speak for the board. You as an individual owner do not and cannot speak for the board and should not. And that is something, if you are caught, for example, on a phone, or if you do decide to call the person back, you'd want to make clear. I think there are different types of questions, and the question presented here doesn't identify what kinds of questions the purchaser may have. If they just want to know where are the garbage cans or something like that, that may be a very reasonable question to answer. But generally speaking, there shouldn't be a problem providing things like board meeting minutes, because that's information available to all owners. But you just want to be really careful about making any promises about condition of the buildings, future assessments, special assessments, things like that, because that could put the association or you as a board member at risk. And you don't want to disclose or fail to disclose any known liabilities or any issues with the building. For example, if you know that you need a new roof and there's going to be a special assessment coming, but there's no special assessment yet drafted, you don't know what the cost is, you don't want to start explaining all this to a potential buyer, because you don't know, you don't have the information in front of you. I think that's, Ken wanted to remind everyone that there is a new resale certificate requirement in Washington State under WCIWA, so make sure that you are complying with the current requirements in your resale certificates. But to answer the question, generally speaking, just be careful with what you say, and not responding is an okay response, I think, in this situation. Valerie, anything to add?
No, well, okay, yes. The only thing I'll say is that the specific language that Ken is referencing when he wanted us to remind everybody about the resale certificate requirement under WCIWA, it includes very specific language about the risks of buying into a community association, which, you know, that's the whole purpose behind a resale certificate, right? Is to make sure that your buyers know what they're getting into. And so you want to make sure, if you are a community that's subject to WCIWA now, that you look at that language that is newly required by the statute and make sure your resale certificates have that in there. The other thing that I will say is, you know, we have dealt with clients not in the distant past where, for example, a board knows that there is going to be some sort of construction project and likely some sort of special assessment as a result of defects in the building. But because they have not yet voted on the project, or they have not yet voted on the special assessment, they don't want to include that information in the special assessment, in the resale certificate, specifically because they don't want to compromise property values because they have the intent of selling their unit at some point in the near future. So I would like to point out that as board members, you have a duty of care to the association. And one of the things you are not allowed to do is allow your self-interest to trump your duty of care to the association. In other words, don't exclude information from a resale certificate that should be there just because you think it might hurt how much somebody's willing to pay for your unit when you sell it in 6 months, right? And that might seem super obvious, but I wouldn't be saying it if we hadn't dealt with that with a client in the past. So moving on to our next question. Who is in charge of board meetings, the manager or the board members? Does WCIWA have an open meeting requirement? Do those apply to committee meetings? And what can a board member do if they believe the board as a whole or management is not governing with accountability and or consistent with statutory requirements? I'm going to preface our answer to this question by saying that if you're the person who submitted it, you might be wondering why the heck we changed the wording in the question. And the answer to that is because your question was far too specific and we otherwise would have had to exclude it. So this is not advice for any particular person or situation. We just wanted to talk about the subject generally in case it would be helpful to the group as a whole. So the short answer to the question of who is in charge of board meetings is that it's the board members. The board has the ultimate responsibility of running the board meetings and of governing the association. Most of the time, the bylaws specifically say that it's the board president that runs the meetings. That being said, the board has the authority to delegate the responsibility for running a board meeting. So the board can choose to delegate running the meeting to a manager. If the board doesn't have confidence in their manager, or for whatever reason wants to have a third party do it, they can delegate to a third party. You can bring in a parliamentarian. We have one client that pays Ken to run their board meetings every month. because that is their solution to difficulty running board meetings internally. And I think there's a number of layers as to why that's the case for that particular community. Wakaiowa and the HOA Act both have statutory open meeting requirements. Some pre-Wakaiowa condos have an open meeting requirement in their documents. So it's not in the old act or the new act, like in the statute, but it might be in your documents. And if you as a community have an open meeting requirement, that would mean your board meetings have to be open to all of your owners. Unless you are a Wakaiowa community, open does not mean that owners get to participate in any way. If you are subject to Wakaiowa, you do have to provide owners with an opportunity to comment at board meetings. That can be at an owner forum at the beginning of the meeting, at the end of the meeting. It does not mean owners get to interject and interrupt and sort of run roughshod over the actual meeting itself. But you do, if you're a Wakaiowa community, have to provide an opportunity for owners to comment. Wakaiowa specifically provides that committees that exercise the power of the board are subject to the same open meeting requirements as board meetings. So if it's a committee that is advisory only, they may not have to have open meetings. But let's say it's your ACC committee and they actually vote on the issues before them and make decisions on behalf of the board. There are specific rules in the statute about having to have at least 2 board members be on that committee, how the board members are the only ones that get to vote. And yes, those committee meetings are subject to the open meeting requirements. So getting to the sort of stickier part of the question, if a board member or an owner believes that the board as a whole or management are not doing things correctly, you only have a few options. One is that you work sort of within the system to correct things and get other people that are on the board to agree with you. Boards rule by a majority or governed by a majority. And on the one hand, just because one board member disagrees or thinks that the board is handling things the wrong way, that doesn't mean that what the board is doing wrong. And on the other hand, if you feel very strongly that that is the case, one way that you can sort of further your agenda, even if your agenda is just compliance and accountability, is by convincing other board members that they should do that, that that's the right thing to do, educating them, encouraging membership in things like WSCAI, attendance at their conferences, read their, the journal that they publish, attend the webinars that they offer, ask your board members to come to Q&As like this or watch the videos on the YouTube channel, etc. You can also resign. If it has sort of, if you feel like you're beating your head against a brick wall and you're trying to correct course and nobody is listening and it's that frustrating for you, one option is to resign and not participate in the governance of that community, which, can feel very frustrating if you think things are supposed to be done a certain way and they're not. If it rises to the level of being so damaging and so compelling that you want to sue the association, that's another thing you can do. But that's really expensive. You'd have to go out and hire your own attorney to do that, and you'd have to pay their legal fees. And depending on the outcome, you might not be able to get those back. You can also, if you really think that, if the issues are really serious and again, rise to a certain level, but the board itself is not convinced, you can try to convince enough owners to become involved, to call a special meeting to remove non-performing board members and elect new board members. So those are a lot of different options, that you can consider. But I do want to go back to the reminder that just because one board member disagrees does not mean that what the rest of the board is doing is wrong. So I think I'm going to stop my comments there. Lisa, did you have anything you wanted to add to that one?
I was just going to mention that, you can also, the board as a whole can strip another board member of their title. So if you think the president isn't doing, if the board agrees that the president isn't doing what the president should be doing, you could strip them of the title of president. They would remain on the board, but they wouldn't be the one then running those meetings, for example. So that is also an option. It is a little less dramatic than recalling and holding a special meeting, but it's still at least may send a message and may help things on your board.
Yeah.
Okay, next question. If an association's governing documents provide for compensation to board members, when can or should that compensation occur? Do we have to wait until the compensation is disclosed in the budget process, or can we pay them now and disclose after the fact at the next budget ratification? I will start by saying that we, generally speaking, do not recommend that board members be compensated for their service. We've talked about it a lot in past Q&As. So if you want to look up prior conversations about that, go ahead and search our YouTube channel for that. I know we, at least in the past 6 months, I know we've talked about it a couple of times. However, that being said, if your community insists on compensating board members, and it sounds in this case, it's in your governing documents, so I guess you do. So if you insist on compensating your board members, and that's authorized by your documents, make those payments only, we recommend, only after the budget in which those payments are reflected has been clearly disclosed to all of your owners and has been ratified. Make sure it's very clear. It's, you know, not buried somewhere in the budget, but that it is listed as compensation to board members or something equivalent to whomever is your treasurer, whomever is doing your budget. That would make it less likely in the future that an owner could object and claim that they had not been properly notified that the budget or that the board was being paid. Generally speaking, we recommend that making an unbudgeted payment and ratifying something after the fact, we do not recommend that. So make sure that if this is something that is in your governing documents, go through their normal budget process, make sure it is very clearly outlined to your owners, and then make the payment, regardless of when the board members want to be paid, make it after that has been properly, your budget ratification has been properly done. Anything I missed there, Valerie?
No, the only thing I would just emphasize, what you already said, is we're not talking about just including this in a line item on a budget that nobody is going to look at. I mean, let's be honest. There are very few owners that actually read through the entire budget spreadsheet, right? I would like to see it called out specifically, like in the cover letter or some other language. And it doesn't have to be like some crazy long statement or anything formal, but it can just say something like, consistent with the recent change to our declaration, board members will be compensated a flat amount of $500 during this budget cycle for their service on the board. Boom, yeah. That's it. It doesn't have to be complicated, but I do think my preference would be seeing it called out like that specifically. And part of, you know, you have to remember when we're answering these questions, we're not just answering them for the perspective, like what's technically required, what's technically legal or allowed. We're also trying to think about what will appear reasonable to a judge in the future when somebody has sued the association over these payments, right? And so reasonable is the standard by which almost all association actions are evaluated after the fact by some third party in the future. So that's what we're thinking about when we are making these recommendations.
And I will also say, I just remembered I had one of these in the past 6 months or so. Make sure that whatever amount you're paying or forgiving or whatever the process is matches what you have in your governing documents, because I do recall running into something that it wasn't the same amount. So that's also an issue, right? Make sure that what you're doing is actually what is authorized in your documents.
That's a great point. Okay, I'm going to move us to the next question. If our documents say that mortgagees, holders of first mortgages, have to consent to amendments, what does that mean? Do we have to contact every mortgage lender every time we want to amend our declaration? What if we have adopted amendments in the past without notifying or getting consent from mortgage holders? Excuse me. The short answer is that it depends on the specific language of your declaration. And to flesh that out further, under the Condominium Act and Wakaiowa, even if your documents say mortgagees, it actually only means eligible mortgagees. And eligible mortgagees is a defined term. And generally what it means is a mortgagee that has filed a document with the association requesting notice of changes to the governing documents. And if you want to look at the specific statute sections that I'm talking about, one is RCW 6490-295, subsection 2, and the other is 6434-272. So the answer is, what do we do? The answer to the what do we do question, if you have this language in your documents, is likely nothing, but you have to consult with your association attorney to confirm that. And one of the things that you hear us say often is that you should not be drafting and recording amendments without the assistance of counsel. And this is one of the many reasons why. We have seen so many problems created by amendments drafted and recorded by lay people. And if you're not an association attorney, this is one term that you don't know what it means. You don't know how to figure out if there are eligible mortgagees. You don't know how to even figure out how to contact the mortgagees if there's a scenario in which you actually do have to do that. And your association attorney knows and can tell you all of these things. It's also possible that if an amendment and if a proposed amendment does not affect the mortgagee's rights in any way, they may lack standing to challenge the amendment. So there was an appellate case that involved the 6001 condominium association, and this was not a holding in the case, but in dicta, as we call it, which means stuff that the court said that's not the actual holding. They suggested that a mortgagee that was not given notice, even when required under the documents, might not have standing to sue if they weren't damaged or harmed by the actual amendment. So some documents that are not subject to the Condo Act or Wakayawa do require the consent of all mortgagees. And in that case, you would want to find out every current holder of a mortgage within your community and give them notice of, and sometimes the opportunity to vote on, depending on what your documents require, any amendments. So again, as this response indicates, this is not a simple question. It's not a simple process, and working with your association attorney is the way that you sort of avoid all of the pitfalls that could arise because of this scenario. One thing that I will offer that is good news, which is that by statute, amendments are only subject to challenge for 1 year after they are recorded, if they are not fraudulently conducted. And that clarification comes from the Club Envy case out of Spokane. So by statute, as long as there was no fraud in the passing of and recording of the amendment, it can only be challenged for up to 1 year after it's recorded. So the second part of your question was, what if we've adopted amendments without notifying or getting consent from mortgage holders? The answer to that is probably, unless there was fraud in the amendment process, if they were recorded more than a year ago, you're probably okay. But again, you need to consult with your association attorney to be sure. Lisa, did you want to add anything to that?
Nope, I think that covers it. Let's see, next question. Regarding the recent legislation on heat pumps, will the provision extending responsibility to future owners of the unit be enough, or would you still recommend something be recorded on title for the unit? The answer to this question depends almost entirely on what type of community we're talking about here. If you are talking about a typical airspace condo with the heat pumps bound within the unit of, or the confines of the unit of the condominium, there's probably no need to record any hold harmless or any other document notifying, on responsibility for upkeep of that unit for future owners. So, but if it's on if it's in another type of community, or if it's on a common element of the community, that might be a situation where you do want to record a hold harmless agreement. I think that's what the person is asking, to make sure that you understand whose obligation it is to repair and maintain that unit in the future. So if it is housed wholly within someone's unit or within their the confines of their property lines, that may not be required because it's obvious that is in their unit, that is responsibility of the owner of that unit. But if it is somewhere else, that is something that you may want to consider talking to your attorney about, recording some type of a hold harmless agreement to make sure that it's understood whose obligation it is to repair and maintain. The statute doesn't necessarily, or does make it clear about whose obligation it is. And so, that's probably something you can rely on if you do not at this point record a hold harmless agreement, but it just for your peace of mind and for future situations, that may make sense to, depending on what type of community you are, to record one as needed. I think that covers it. I'm trying to think if there's anything else. Valerie, did I miss something there?
No, but I think I am going to explain a term because
Okay.
it was, I don't know, a year after I started working at the firm before I knew what an airspace condo was.
Oh, thanks.
So
Yeah.
there are different types of condominiums in terms of where the unit boundary is. In a traditional like multi-family building, what we normally think of, what most people, especially out of the industry, normally think of when they think of a condo, you know, a building with 4 units or 20 units or 100 units, the boundaries, depending on which statute you're governed by, let's say you're a new act condo, the boundaries of your unit as a unit owner are basically the finished interior surface of the wall in. That's what you own, right? In an airspace condominium, the boundary of the unit includes the structure of the building. And so most often we see this in a scenario where a condominium is the organizational structure of the association, but the actual construction of the buildings is like single family homes. It looks like single family homes from the outside, but legally it's a condominium, right? And so in an airspace condo, even if the heat pump system is, you know, installed on the outside of your building, the boundaries include the structure. And so that's part of your unit, and it would be understood by any future owner that, you know, yeah, that's that AC unit attached to my house, or heat pump unit, whatever, I have to pay for that. In a more traditional condominium structure, at least some part of the heat pump is going to have to be installed on the exterior of the building, which is almost always going to be a limited common element or a common element. And that's when I think having that hold harmless recorded can be helpful, not because it makes it any more true that subsequent owners are responsible for maintaining the heat pump unit. The statute does say that, but the statute is not included with the resale certificate. There's no notice. There's not going to be notice to future buyers of that unit unless there's something recorded on title, and that's what the hold harmless does. There's a question in the chat, a follow-up question as to who records the hold harmless agreement. We draft these for our association clients, and the association and the owner sign them and get them notarized, and then we get them recorded for the association. Often there is an agreement to share cost or for the owner to reimburse the association for the cost. But again, you know, that's something that you can negotiate on a case-by-case basis. You should consult with your association attorney if you're wondering how best to handle these going forward. All right, next question. What are the voting requirements to amend our bylaws in Washington State? Can the board alone approve amendments to the bylaws, or do they require a community vote? I'm having a difficult time finding this in the Condominium Act. So the answer to this is that it depends on what your actual documents say. Many bylaws can be amended by a board vote only, but some require a vote of the unit owners. So the first place to look is to your governing documents, because the procedures and the percentages required to amend your documents should be outlined in your documents. So for example, RCW 6490-435 states that your organizational documents must specify a method for the unit owners to amend the organizational documents. That's from Wakaiowa. RCW 6434-324 subsection 1 subsection E says that the bylaws shall provide a method of amending the bylaws. And the same is in the HOA Act as well, 6438-030. So one thing to keep in mind, though, is that Wakaiowa does state at 6490-410 that the board may not, without vote or agreement of the unit owners, amend the organizational documents of the association. So if you're a Wakaiowa community, you need to work closely with your attorney to understand the statutory requirement to get owner vote or agreement before you amend your bylaws. And then side note, that's not about voting. If your bylaws are recorded, they're not required to be, most are not, but occasionally we see them recorded. Any amendments to them have to also be recorded, or better idea, you should record a rescission of the original recorded bylaws, so then you don't have to record any later amendments. So just pay attention to whether your bylaws are recorded and work with your attorney on how best to handle any amendments. Lisa, did you want to add anything to that?
Nope, I'll just go on to the next. Okay, Next question. Our association's lawyer has advised that owners have no right to question board members or the manager about interactions between them, like assignment of task, instructions, etc., or to ask about the association's decision-making processes in general. I know that Condo Law Zoom Q&A has often expressed the view that a board should share as much information with owners as possible, but if they choose not to, is there some legal rule that says owners have no right to inquire about the sort of issues noted above? And I will start with the caveat that it is generally our firm's practice not to second guess other law firms. I don't know if this is our firm's advice or someone else's, but if they're a qualified association attorney, it's not our position to second guess the advice. But I will say that it's hard to know, because it appears that the person asking the question may not have been the person receiving the direct advice or communication from the attorney, what was involved in that conversation or in that memo or in that advice giving. So I don't know specifically what that law firm's.
Lisa's being very diplomatic. I'm totally going to interrupt. I said that if this advice is coming from a qualified community association attorney, there is more to the situation than the question suggests. And that's not to say that the person who submitted the question is lying. I'm certainly not suggesting that. But we've all, okay, think back to your childhood. Those of us that are old enough that grew up playing the game of telephone, this was the analogy that Lisa used. Yeah. The board asks the attorney a question about a specific scenario. The attorney answers. The board synthesizes that information. 2 months later, a board member says to an owner, well, our attorney told us X, Y, Z. We have no idea what the original communication was about. And I think all of the firms in our practice area would never say, you don't get to question how the association makes decisions to any owner. Okay. So that being said, we could be wrong, but you're being very diplomatic about it. And I'm a little more blunt. So carry on.
Well, I was going to say, we all hear what we want to hear. So the board member may have heard what they wanted to hear also, and then conveyed that information to whomever was asking. And I think the key here is everyone has a right to inquire about whatever they want to inquire about. And that's right. What the question asked, right? You can ask any question you want. Whether the board is obligated to provide that information to you is a different question. Yes. There may be situations, for example, when a board retreats to executive session to talk about something that is that a litigation matter or something like that, that may be something that is not appropriate to disseminate to all of the owners in a community. So there may be some things, maybe negotiating contracts, for example, could also, not the ultimate contract, but the process of discussing contracts or bids or things like that may be something that is more quote unquote secret or subject to non-disclosure to the entire community. But generally speaking, the owners can ask whatever or inquire, to use the word that the questioner asked, whatever they want. All of the statutes that we talked about we talked earlier about records disclosure acts, all of the 6434, 6438, 6490, all have records disclosure provisions. And so if the information an owner is seeking is included in the things that are supposed to be disclosed, that's the answer to your question. We wonder if maybe this isn't a community that is subject to open meeting requirements, and that is potentially part of the, you're not seeing how the sausage gets made, to use an old terminology or old idiom. And so that may be part of the problem that the owners are having. They certainly have a right to review board meeting minutes. They may not have a right to attend the board meeting that's not an open meeting, but you do have, as an owner, a right to review any record and or any record under the statute, and meeting minutes are one of those. So it's hard to know. There's a lot here that we don't know. And there's a lot, obviously, as Valerie said, we just don't know what the advice of the attorney was either. But if a decision is made by a board, that is something that should be reflected in the board meeting minutes, whether the meeting is open or not. And so an owner would have a right to see what was documented in those minutes. And hopefully that would answer the question. Again, there's a lot here that I think we're missing, but that is sort of generally speaking what an owner is allowed to do. And again, an owner can ask anything they want. Whether they get the answer is really the question, I think. Anything you want to add to that, Valerie?
The only other thing I would add is if the association is working with a reputable, qualified community association attorney, then I think that's if the board is acting on the advice of an attorney who knows what they're talking about, that's the thing that would be the most important to me, like if this were my community. So.
And I think we did talk about earlier, and I forgot to mention that some things, there's been a real big conversation about whether emails of board communications are subject to disclosure. So there are some things that, that may have information in them that an owner may not be entitled to, but we can't comment on that here, but there may be other things.
Okay, I'm going to move on to our next question so we can try to get to all of them before we're done here. We are confused by the wording in RCW 6438-120 subsection 6, which says, unless prohibited or limited by the declaration or organizational documents, the association can conduct a vote without a meeting. In that event, the following requirements apply. There's a list of requirements, including the amount of notice before such a meeting such a vote takes place, which by statute is 14 days. And the question essentially is, if the bylaws specify a different number of days, does the statute or do the bylaws control? And the answer to that question is, the statute is the baseline, but if your documents require more notice, then you should comply with that notice amount as well. So the documents control as long as the statutory minimum amount of notice is met. So let's say your bylaws specify 10 days, you still have to give 14 days as required by the statute. But if your bylaws say 20 days notice, give the 20 days notice because that complies with both your bylaws and the statute, right? Also, as an aside, the statutes do allow a community to prohibit voting outside of a meeting, meaning you can set up your governing documents so that the only way to vote is with an in-person meeting where a quorum is achieved. And it is also possible to prohibit proxies, but only if you put that in your declaration. I almost hesitate to even say that because we generally recommend against prohibiting proxies for a lot of different reasons, but it is possible by statute to do that. And I think I will leave my, tangential comments aside since we're running out of time.
Okay, I've got nothing to add to that, so I'll just go quickly to our next topic. If the board is unhappy with a contractor's work, what are their options and what does CLG look at to determine if a community has recourse against the contractor? And this one has come up for our firm in the last few months in a number of cases where an association has either paid a contractor a large sum of money as a deposit to get work done under a contract that they've negotiated with the contractor or have signed with the contractor, maybe not negotiated. And then the contractor has run off, gone out of business, or not performed the work to the association's standards. And sometimes that might come up later. So 5 years later, the association might come to us and say, we don't like what this contractor did, or we don't like how they did it. Can you tell us what we can do? So I will say that the first thing that your attorney will look at when you ask this type of a question is, we want to see the contract. So if the contract has bad terms for you, let's put those in quotes, bad terms, you're likely not going to get the result that you want. You will have a very limited or possibly no means to recover if you go with the standard contract that is provided for you by the contractor. I'm just being blunt there. It is our recommendation, generally speaking, that if you can't afford to lose the money that the contract requires you to put up, then you shouldn't be giving that money. And if you can't afford that, then you should be talking to your attorney about helping you craft either the contract, or I think we also will do some contract addendums that will protect you and protect the association from either bad work or from the contractor who runs off, or, hopefully this is all just a esoteric conversation, but it can happen that a contract will require a 50% deposit and an association will chunk down $10, $20, $30, $50,000. And either the work is not done, the work is not done appropriately, or things aren't done on the schedule that was agreed. So always, if you can afford it, and usually it is peanuts compared to the price of the amount of that you're at issue in your contract, have your attorney review and revise the contract terms that are more appropriate for your association. Generally speaking, we caution against any advanced payment for services if the materials are not actually received on your site. So for example, you're paying for the siding and the siding is at your location, then it may make sense again, talk to your attorney about that, but that may be a time when you would pay something up front. But generally speaking, we don't recommend that. A financially sound contractor won't ask you for a lot of money up front. So keep that in mind, especially in light of some things we've seen recently where a fairly well-known contractor is no longer in business and kind of left a few communities high and dry. Trying to get through that quickly. Anything? Oh, I know Ken mentioned, some folks have come back and frequently and say, here's our contract. It happened 5 years ago. You didn't help it. Can you help us? But they didn't do it right. That kind of puts you in a position of potentially not getting what you want, because it's hard to interpret things after the fact and it's already been completed many years ago. So make sure that you protect yourself in advance if you can by having your attorney help you get the contract that makes sense for you. Anything I missed? Oh, we're over time. Didn't even pay attention.
Yeah, I'm going to add just one thing really quickly and then we'll let you go. It does depend on the amount of the contract. It
Yeah.
probably doesn't make sense for you to pay your attorney $600 to review a $2,000 contract, right? But if you're talking about a $20,000, $50,000, $100,000 plus contract, the amount of money that you pay your attorney to review that will seem like peanuts if there is a dispute and you're actually able to recover successfully because of good contract terms. So just keep that in mind. And on that note, we are over time. So thank you for being here with us today. We will see you next week. Bye, everybody.
Bye.